Okay, good evening, and those of you who are refugees from the football, and welcome. So my name's Ian Fish. I'm the chair of the BCS Information Security Specialist Group, and it's my pleasure to introduce Jonathan MacDonald, who's a partner in Charles Russell Speechleys, and who's back by popular demand because he spoke at our event last year before the lockdown, and there was lots of clamour for him to come back. So we've met that clamour, and he is back. So, what do I need to tell you about? Well, firstly, the rules for how we run these things. Please ensure that you have your microphone on mute and your video off during the presentations. You'll have an opportunity to ask questions at the end. We'd rather not do it during the talk, if that's okay. And it would be very useful if you could send your questions in advance using the chat, but you'll also have the opportunity to raise your hand during Q&A. And you can interact with other attendees as it's going on through direct messaging or using the group chat. So we encourage you to do that as we go along. Now, this will be being monitored by Paul Skinner, who I must thank for setting this event up, along with the rest of the series that we've had running. This is the third in the series, which is really very good, and they've all been excellent. So, what are we going to talk about today? Well, basically we're talking about fines, sanctions and liability, what it looks like up to now and what it's going to look like in the future. There's been some interesting things happened even quite recently, I think, in that space. So I think Jonathan's got lots to chew on. And as it says at the bottom, this event forms part of the ISSG legal series. And I apologize for the extra space in the second last paragraph. I'm not sure what happened there. So I think you've all read who Jonathan is. He deals with lots of technology related stuff for a very large international company, legal company. So he's a really authoritative speaker on this topic. So I'm looking forward to hearing from him. And with that, I think I will hand over to Jonathan, and I will take my share off and let him share his screen, and he can start to talk to us. Thank you, Jonathan.
Thanks, Ian. That's very kind, and I shall, hopefully this will work, and I shall share my screen now. Fingers crossed.
Thank you.
We're now looking at our cover sheet. Well, as I say, thanks for the introduction. It's a pleasure to be back here. It was a very useful discussion last time and has been mentioned. We got lots of questions at the end, which is always great to make these sessions slightly more discursive, and it always makes it more engaging for the speaker too. As Ian said, I'm going to be talking about for the next about 35-40 minutes or so, leaving plenty of time for questions if we have any at the end on the subject of fines, sanctions and other liability issues. More specifically, this is what I'll be covering. So firstly, starting off with just a reminder about the ICO's priorities and its powers. It's useful to remind ourselves what those are. Then, as Ian mentioned, this idea of having a quick look at what we have seen over the past 12 months, so regulatory action of note and some of those big eye-wateringly large fines that we have seen. And then we're going to turn to litigation, having a quick look at some of the trends that we're seeing in the contentious area of data protection, before spending a few minutes focusing particularly on the big case of 2021, which is Lloyd v. Google, and just going through that and having a look at what the implications of that case may be before finishing off with our Q&A. So starting off with a reminder of the ICO's priorities, and we thought the best way of doing this was to have a quick look at its regulatory action policy. Now, for those who are familiar with these documents, if you ever had the chance to have a read through it, if you've ever been struggling to sleep at night and decided this is the way to try and cure your insomnia, they're generally of sufficiently high level terms. There's little of tangible value for individual businesses in there. You're trying to plot your compliance course, but it's useful nonetheless, because does give you a hint of the ICO's priorities in terms of its approach, in terms of those activities that it's particularly focusing on. So looking at the current version, which is dated 2017 to 2021, although it's been updated in that time, some of those listed priorities have been protecting the public interest, no particular surprise there, focusing particularly on information rights issues most likely to result in distress or harm. Secondly, looking at data sharing, which since the GDPR has come into force has been a particular topic of interest to the ICO. We saw a couple of years ago this idea of the charity sector, for example, getting into trouble around data sharing and hidden data sharing that was taking place. And then the third priority, which the ICO has particularly listed, is monitoring intrusive and disruptive technology, which is potentially of interest to an audience of this nature. So noting that inclusion of intrusive technology, one of the key things the ICO is getting at here is artificial intelligence and machine learning, which is going to be a huge area of development for technology in the next couple of years, but has big implications for data protection and privacy. So why is it worth focusing? I introduced this by saying that the regulatory action policy is always drafted in fairly high level terms, but it gives a hint of what's going on. So what lessons can we learn? What lessons are to be drawn from the policy this time around? Well, the first thing I'd say is that it's useful to focus on this because the policy in some respects acts as a check on the ICO's powers, on the ICO's enforcement powers. We'll talk about slightly later on in the presentation in the context of the British Airways fine and the Marriott fine that was initially announced and then reduced, how those businesses were able to use information from the policy to their advantage to get those fines reduced. And then it's also worth mentioning that the ICO in providing this policy is doubled down on the fact that it is a pragmatic regulator. And of particular note there is I say about this update, which we saw in 2021 in relation to obviously the COVID-19 pandemic. And what the ICO said was, we're flexible, we're taking into account the effect that this is having on businesses. We're a pragmatic regulator. And we saw this as practitioners in real practical terms, that the ICO was sympathetic to businesses that were essentially, facing shortfalls in operating capacity, shortfalls in staff who were potentially furloughed, and acute financial pressure that they hadn't seen before. So if, for example, you were a recipient of a subject access request, the ICO was sympathetic to the fact that you may not have individuals in the business who could deal with that at a particular time. They were more sympathetic to extensions, more sympathetic to that, to the unique requirements that businesses had during this period. So if that's what the ICO's policy looks like for the last couple of years and going forward into 2021, 2022, a quick reminder of its powers to sanction is also fairly useful. We're going to be talking about remedies and liability and that kind of thing. So these are the ICO's investigative and corrective powers. It's well known that the ICO has two sets of powers under the GDPR. It can investigate what you're doing, and then it can sanction you if it doesn't like what you're doing. And it's quite clearly split down the middle, as is shown on the slide there. And it's useful to focus on the ICO's powers because although litigation, and we're seeing an uptick in litigation, which is of concern to businesses, or of concern to anyone who's processing personal data, it's worth remembering that any aggrieved individual's first port of call will most likely be through the regulator. And the most important reason for that is because it's cheap and easy. It costs you nothing to make a complaint. You have wide grounds to make a complaint. Any infringement can entitle you to make a complaint at the ICO. And then for no cost to the individual, you suddenly have the ICO potentially a huge weight of resources to investigate what's going on. So digging down into a little bit more detail, okay, what are these investigative powers? A reminder of those. Well, firstly, the ability to issue information notices. Now, this is a very broad right, but it is set within certain parameters. It can't be used arbitrarily. And this is going back to this point that we talked about, the regulatory action policy setting out what the parameters of the ICO's actions are. Equally, however, it can be very disruptive if you do receive one of these. And I always say this because the ICO may not initially request information which is particularly difficult to provide. It may not initially kind of dig so hard that it's going to be a huge cost in time and resources trying to respond to them. But what they are is they are dogged. They don't give up. So if you aren't able to provide the information, if you aren't able to provide the answer that they are getting at, then they will keep on going, and that's when this can become incredibly disruptive. Also, failing to respond to an information notice is of itself an offence, which means very serious repercussions for businesses. Now, there's exemptions which are worth mentioning as well, whilst we're just kind of focusing on this idea of information notices, and the key one of which being legal privilege. So either legal advice privilege or litigation privilege, which can be very helpful. And that last point on information notices that it's worth focusing is that it's important to understand that the ICO will write to businesses under lots of circumstances, and it's useful to clarify whether what you have received is a formal information notice request or whether it is informal correspondence, and that may dictate your response. Next, moving on briefly to assessment notices. Now, these are obviously used more rarely, used where there is more serious concern, and therefore less frequently seen. They can be very serious, though, if received, and can include, essentially, as it mentioned on the slide, the right of audit. Now, we've seen these in certain cases. Some of us have seen, you've seen the photos of the ICO in their bomber jackets with Information Commissioner's Office written on the back, kind of raiding Cambridge Analytica and that kind of thing. So we know that there is this serious power that the ICO has. It's worth bearing in mind that that is a gradual response. It's something which can be escalated. So there are 3 categories of assessment notice that you may receive, either ordinary, urgent, or classed as super urgent. And the ordinary, you're going to have notice. This isn't like a dawn raid, varying down to essentially the super urgent, which is in theory can be given without notice if the ICO gets a warrant, in the case where it suspects serious harm or a serious breach of rights, thinks an urgent investigation is needed. For example, evidence is going to be destroyed, then it can essentially undertake a dawn raid, more of the terms that we've seen in competition cases. And then other rights of entry inspection mentioned on there too as well, which are rarely used but can be serious. Then moving on to, once again, just a reminder of the ICO's powers on the corrective side of things. I don't intend to go through each of these because they're self-explanatory, but I would just pause on 2 particular ones. The first one is the power to issue a ban, either temporary or permanent, on an organization's processing. Now, I mention this because looking at that list there, that is essentially one of the most draconian powers that a regulator has. If you're undertaking something, if you're doing something, then generally that's probably contributing to your business. And for the ICO to suddenly say, stop, you can't do that anymore, can have very serious effects. And then the other point to note on that slide is the idea of imposing fines. And I say this because that is, really one of the kind of headline points of the ICO's powers that questions get asked about all the time, generate a lot of column inches, and can also have very serious implications for businesses. Which brings us on to our next slide, where we're just going to spend a few minutes having a look at some of the more recent fines that the ICO has issued in the last 12 months or so. The details of these are on the slide. I don't intend to go through each of those bullet points in turn. Some of this will be well known. So we knew that BA suffered a serious data breach. We knew it had originally had a huge fine issued against it, or a notice of intention rather than a fine, and that was reduced. The same happened in the case of Marriott as well, so same applied. And then the third of that trio of very well publicized in the last 12 months fines that the ICO has issued is Ticketmaster, which received a fine for 1.25 million. Now, these three cases are regularly cited as the ICO really flexing its muscles. We see that this is complemented across the European Union as well as the UK, with other regulators taking a similar approach, with obviously Google's fine in France for 50 million euros being one of the key ones, which is also cited. The ICO has also been very busy exercising its powers in the last 12 months with enforcement measures of a much smaller nature, which are also important. But what are the issues of note? What can we draw out from these fines that we have seen? Well, the first one, which relates to British Airways and Marriott, is the fact that there was obviously a reduction in the fine that was originally handed out. So the ICO issued its notice of intention to fine. We had these huge, eye-wateringly large amounts. Then when the fine was actually landed, it was far smaller. Now, there's a couple of points that contribute to that, one of which was the COVID pandemic itself. We've talked about the ICO being a pragmatic regulator, and it took that into account. Obviously, the airline industry, British Airways, and the hospitality hotel industry, Marriott, were two of the sectors more badly affected by the pandemic than anyone else. And the ICO took that into account, but that clearly didn't account for the total reduction. We're seeing a reduction of almost at 90% or 80% in the case of Marriott. So what else contributed to those? Well, one of the main reasons was that the appeal that British Airways and then Marriott respectively put in were successful. And this comes back to the regulatory action policy that we talked about earlier on, because what BA and Marriott were able to say was that the ICO had incorrectly applied its own parameters. It has a 5-step approach to working out what those fines should be, and it hadn't conducted that properly. So it challenged the fines. So the businesses challenged the fines that were issued against them, and they were successful. What other lessons are to be drawn from these fines that we've seen here? Well, they're all obviously pretty serious. They're all involving a very large number of individuals, which accounts for the high monetary amount. This is why they were so much. One of the other reasons why these fines were so high, massive amounts by any estimation, millions of pounds, far more than we've seen ever before, was that they were serious breaches of technical and organization security measures that could have very easily been avoided. They were flagrant breaches, flagrant disregard for fairly fundamental measures. And there's 2 points from that. First, obviously, if any one of these businesses had taken better care of their security requirements, if they had put in place better technical security measures, then they may not have suffered this breach. If we look at the issue of Ticketmaster and what happened there was they had a chatbot on their payment page, and that chatbot allowed access for a malevolent third party to access payment card details of customers. Ticketmaster were warned about this and elected not to do anything for 9 weeks, which during that time then and individuals suffered further, had further, their rights and freedoms were affected further and suffered considerably more monetary loss than may otherwise have happened. So if they'd have put in place these measures, then that would have helped mitigate the risk of these things taking place. Equally, the ICO is not necessarily in a position to accurately dictate what a what a reasonable, what a proportionate, what a appropriate technical and organizational security measure is. It's not that, even as a regulator, it's not that sophisticated. If I say, well, I think this was reasonable, I think my security measures were reasonable, the ICO isn't really in a position to second guess what I have said. However, if I've not done anything, if I've had these kind of flagrant disregard for things like training, things like basic organizational security measures, a proper chain of command, for want of a better word, that enables me to escalate issues that are reported to me to the appropriate authority so I can react. If I don't have any of those in place, those basic measures, if I can't demonstrate that I had a policy in place, that I had training in place, then that's something which is very easy for the ICO to get its hooks into, to say, well, look, you didn't do anything. You didn't have any of these measures in place. So one of the key lessons is to remember the basics, and to think about that idea of accountability that we have under the GDPR, being able to show that you are compliant, being able to show that you do have these policies in place, can be very helpful. So that's a quick canter through some of the recent issues we've seen with the ICO's fines, and a quick reminder of the ICO's approach, its policy approach to sanctioning businesses. So next, we thought it would be helpful to have a quick look at the litigation landscape, and that's what this slide does. It takes us through some of the developments that we've seen in litigation in the last 12 to 18 months. Some of these have been seismic. We're going to be talking about Lloyd v. Google in a moment, and the implications that has. In general, however, there has been a huge kind of uptick in these claims, and there are certain themes that are starting to come out now that we've had the GDPR in force for 3+ years, that we're able to see certain themes developing. But firstly, just touching on the types of claims, and this is important also in the context of the Lloyd v. Google case that we are going to have a look at. There are 3 broad types of claims, one of which will be very obvious whether you're a lawyer or not, and that is the individual action. So I have suffered some kind of harm or damage. I am going to sue you. I have a right to compensation. I can take you to the courts. However, also we have these group litigation orders and potentially representative actions. And it's worth just drilling down into what those are as well. So group litigation orders are essentially an opt-in regime to allow for, as the name suggests, group litigation, where there is a group who has suffered the same type of loss or damage. They can channel that into one claim. Now, we talk about these being an opt-in claim, and the reason for that is that claimants who are identified in the proceedings need to actively opt in to be involved. Now, this is important because it serves as a natural drag on the size of these claims. It means I need to have a particular interest in order to want to get involved, and that particular interest may be driven by the fact that I have seen an advert for a claimant firm of solicitors who are advertising for me to get involved in one of those claims. But I need to have gone through that kind of conscious decision making process to think, yes, this did affect me, and I should therefore become involved. What we're seeing in Lloyd v. Google is slightly different, and we'll talk about how this may play in a moment. But what Lloyd v. Google and what this third class is, are representative actions, is essentially that is an opt-out claim. So if the claim in Lloyd v. Google goes a particular way, then it may open the door to this idea of US-style class actions that we haven't seen in the UK before. And what this means is that if a claimant is able to demonstrate that they have suffered the same wrong, they have experienced the same wrong, and they've all sustained the same loss, then one individual can launch an action representing the interests of others. And that's exactly what we've seen in Lloyd v. Google. And that can be particularly concerning for technology businesses where potentially, you've got a huge number of claimants. You look at the number of people who use Google, and we'll be talking about that in a moment. And that can potentially have very serious consequences for those businesses if they are able to automatically be joined to those proceedings and a claim brought on their behalf. So what issues and what themes are we seeing here? Well, we've already talked about this idea of an uptick in each of these. So we have seen a serious uptick in the number of individual actions that we are experiencing as a law firm ourselves, representing defendants. We are seeing more group litigations, and then this idea of representative actions, opt-out claims. So we have Lloyd v. Google, which was actually brought under the Data Protection Act 1998, so under the old regime. But since then, we've seen copycat actions under the GDPR because the sanctions are essentially the same. So we're seeing more of each of these. Now, in some respects, this is unsurprising. It's long been predicted that this would be a real growth area, and there's numerous reasons for that. Firstly, a greater understanding of individuals' rights. People are more aware of their privacy rights these days and potentially more aware and able to therefore exercise their rights. Quite simply, we've seen a greater amount of advertising amongst claimant lawyers. Lots of high street law firms will now have a section on their website that talks about data breach claims. And then thirdly, the regime is simply becoming more mature as well. So we're starting to settle in and see real patterns. But what this means is we're increasingly seeing a bit of a kind of a compensation claims market developing, running parallel to, as we say, the group litigation orders, the representative actions, those huge actions which are potentially very disturbing for big tech businesses, for online intermediaries like Google, which have the potential for huge billion-dollar claims. But for lots of normal businesses, normal tech businesses that aren't so high profile, the fact that claimant law firms are potentially being able to drive this business is also worrying. And it's particularly worrying because lots of data protection claims can be, they may well be defensible, and they may well be low value, but they can be very complex. So there may be a tendency, a quite understandable kind of commercial reaction, just to try and settle some of these claims rather than go to the cost and effort of trying to defend them. So kind of just continuing on this issue of themes, what types of claims are we talking about here? Well, unsurprisingly, they'll very often relate to security incidents. We're talking about potential data breaches. That's obviously very, very common. And the main reason for that is because people become aware of these, partly due to the mandatory data breach notification regime under the GDPR. And potentially there are also grounds to notify individuals as well as the regulator as well. So people are finding out about it. Off the back of that, if the ICO does sanction a business, so which it may not necessarily do in response to a data breach, but if it does, if it sanctions a business, then it's very easy to make a piggyback claim off the back of the ICO saying, we have looked at what you have done and we think that you have infringed these particular provisions of the GDPR. Very easy for claimant lawyers to piggyback on those and base their claim form around those. An important lesson, therefore, is not to necessarily accept that the ICO investigates and looks at what you've done, not to necessarily accept that on face value. If you think, well, actually, what you've done is you've issued some informal guidance as opposed to a more formal decision notice, and I don't necessarily agree with what you have said. And the third, when we talk about kind of themes that we're seeing, is this idea that claimant lawyers are really throwing the kitchen sink at these claims as well. So they will cite a breach of data protection, or they will cite an infringement of data protection, or they'll also potentially cite breach of confidentiality, and they may also cite a breach of the right to privacy. And we've also seen more recently in claims as well, where people are taking this idea of the Lloyd v. Google claim, which we're going to talk about in a moment, and citing a loss of control over their personal data as well as an additional claim, which comes down to this idea of these claims being low value but potentially very difficult to defend, because when you've got those kind of full claims, complex areas of law, it can be quite expensive to try and defend your position. So drawing some of these themes together that we have been talking about, I just wanted to spend 5-10 minutes finishing off talking about the Lloyd v. Google case, and particularly this idea of a loss of control claim. Now, I've mentioned Lloyd v. Google several times during this presentation already, and I'm sure there'll be lots of people in the audience who have heard of it independently and have heard of the fact that people are talking about it potentially, depending on the direction the Supreme Court goes, could be a seismic shift in what's going on. And there's two reasons for that. One is we've mentioned already this idea that it could open the door for representative actions. It could open the door for these opt-out US-style class actions. Secondly, as is shown on the slide here, what it could do is potentially give rise to a new claim for a loss of control of personal data, giving somebody a right to claim damages without anything else. And that's what we're going to drill into for a moment. So just by way of very brief kind of background, where we are at the moment is that the Court of Appeal released its judgment last year. And in that, it said, you can claim for a loss of control of your data. That is a standalone claim that could entitle you to compensation. I'm going to explain why that's the case in a moment. It also said potentially UK law permits opt-out class actions, which we talked about as well. So that was obviously appealed by Google, very serious implications. That judgment went to the Supreme Court. We heard that the court heard that judgment in the spring, and probably around about kind of autumn time, we'll receive that judgment and we'll know which way the court's going. Taking a step back around, just have a quick kind of look at the facts of this case. Now, as I mentioned, this was a claim under the Data Protection Act, and it dated back to 2011, 2012. It was to do with what was known as the Google Safari workaround, whereby users of Apple phones could apply certain security settings that should have prevented Google from placing advertising tracking cookies on those devices. Now, Google had an illicit way around this. They had a clever piece of technology that sidestepped that requirement, so they could go on collecting data, they could go on processing data, and they could go on serving behavioral advertising to those individuals, and that was known as the Safari workaround. Now, under the Data Protection Act 1998, and the provisions regarding compensation are identical under the GDPR, and as we've already mentioned, we've already seen a few follow-up claims that you are entitled to compensation for any material or non-material damage. And what this case was about was whether those individuals who had suffered because of Google illicitly processing their data in this way, whether they could arguably say they had, or whether they could argue that they had suffered material or non-material damage. Now, in order to do that, it's useful to have a think about what we're talking about when we talk about a loss of control, what that actually means. Now, it's not a term which is defined or recognized, for example, under the GDPR, but in some respects, it's pretty easy to understand. If somebody is processing in accordance with the law, then there are a series of checks and balances that mean they process data in a certain way, which it enables me to retain control over that data. They've got to tell me what they're doing, so I know I could exercise my right to access, for example. More particularly in the case of cookies or similar technologies, as was key here, they need to ask for my consent in order to process that data, so it gives me real control in that respect. And if you start processing illicitly without those checks and balances in place, because I don't know what you're doing, you haven't told me, because you should have asked consent and you haven't done, that type of thing, well, that's very likely going to involve an infringement of the GDPR. But that doesn't necessarily mean, sorry, so that's an infringement of the GDPR. Okay, I could take action. I could report you to the regulator, because I have a right to report you to the regulator for any infringement of the GDPR. So I find out about it. I could make sure that you get punished for doing this. It's not as if you get away scot-free. But the question is, have I, just because I've lost control of my data in that way, have I suffered any material or non-material damage? Have I suffered any material damages and economic loss. Have I lost any money because of this? Or have I suffered any non-material damage? Have I suffered any distress because this has happened? Well, arguably, on the distress front, I may well have done. I may well be somebody who's particularly sensitive about this. And the fact that my activity online is being tracked in a way that I wasn't expecting, I might find that incredibly concerning. And if, depending on a particular individual, that could have a serious effect on them. That could have some kind of psychological impact on them. So that I could have suffered some kind of non-material damage. But in the Lloyd v. Google case, that wasn't necessarily helpful for the claimant trying to bring a class action, because you've got to assess that on a case-by-case basis. Yes, I may have suffered some level of distress, but the chap down the road hasn't, because he's not as sensitive as I am. So you need to look at that on a case-by-case basis, and that means you can't bring one of these opt-out class action claims, because the damage we have suffered is not uniform. We are not all of the same class. So what the claimant said, what they argued here, is, well, actually, you've suffered material damage. We can tie this down to being an actual kind of economic harm you have suffered, just in the fact that your data has been used without you having any control over it. And what they argued, and what the Court of Appeal looked at, is they said, okay, well, one way of looking at this is the fact that Google has made some profit from the fact that they have used your data. If they hadn't been able to do so, well, they might not have made ad revenue. So let's try and attach an economic value to that. And even if that's a tiny, piddling little amount, even that's, a couple of £100 or less, even that's kind of, £30 each that Google have made per individual, even less than that. What we're talking about in this case, a potential class of claimants who are numbering millions, 4.4 million people. So that can be, very serious for businesses, even if the amount of compensation being claimed is low. So that's what they said. This data has an economic value, so that's how we're going to cite it. They made £30, you should get £30 back. If they made £300, you should get £300 back. And this is a particular concern in the technology sector. Because if you look at the way a technology business works, you're not like kind of professional services where it's a very bespoke service or client by client. In the technology business, it's very often the case that the service you provide is pretty uniform across your client base, across your customer base. So if one thing has happened in relation to one claimant, it's one customer, it's arguably happened in relation to lots of customers. So this could be escalated very quickly, and you could find that the class of claimants against you is very large potentially. Secondly, one of the concerns here is that the GDPR was never really designed to do this, because if you take it to its logical conclusion, the fact that any loss of control of my data therefore gives rise to potentially could give rise to a claim. Well, how does that map against, for example, the GDPR's provisions around breach notification? Because the GDPR says, well, in certain cases, a personal data breach may not be sufficiently serious that it's reportable to the regulator. Now, if there's a personal data breach affecting my data, well, I've clearly lost control of that data. But hang on, this isn't sufficiently serious that the ICO needs to find out about it, let alone me. Well, okay, how does that work? Which is why this is a particular concern for the tech space. And as we say, judgment's expected in the autumn, and if the Supreme Court finds if it upholds the Court of Appeal's judgment, then we could potentially see a lot more of these claims going forward, which the tech industry will need to contend with. Now that's taken me up to 6:40, and I wanted to leave some time for questions at the end. So just to conclude, really, that it's long been predicted that data protection and privacy litigation was going to be a growth area. We're going to see a lot more action in this space, and certainly on what we've seen in 2021 and what we're forecasting for for the 12 months ahead. This really is going to be a year when these type of actions come into their own, which has implications for businesses up and down the country. And on that note, I shall bring my formal presentation to a close.